Would you ask Dr. Smith to come back in, please? Thank you. Good. All right, Dr. Smith?
Yes, thank you.
Good. Thank you. Yes, Mr. Willett.
Thank you, Mr. Chairman. Dr. Smith, we were looking, before we broke at lunch, at where things stood in the spring of 2016 and the CWC meeting on the 17th of March 2016. Now, do you remember that in the January of that year, the BRE sponsored a conference together with Siderise about cladding?
I couldn't have told you what date it was or anything, but I mean, I take what you're saying as correct.
Well,
Yes.
it is
Yes.
correct because we've got a video and we've got a transcript, and it certainly happened. My question is, do you remember it?
I don't believe I attended the conference, no.
Do you remember the fact of it? Do you remember that it happened?
I think I was aware that there was a conference.
Right. Do you know who organised it from the BRE's side?
No, I don't, although I would expect that it would have been done in conjunction with our marketing team.
Right. Did you have any role at that time in arranging conferences or having any kind of involvement with them where they involved industry participants?
No, the only conference that I've been involved in organising over the last few years has been the BRE Fire Research Conference.
Did anybody tell you after the conference what topics had been covered, what areas of concern had been raised, or matters of that nature?
Not that I can recall at the time, no.
Right. Did anybody show you the slides that had been produced by some of the participants?
No, they wouldn't have done.
Did anybody tell you, to see if this triggers a recollection, that a gentleman called Nick Jenkins of Boothmury had addressed the conference on the dangers of ACM?
No, I wasn't aware of that at the time. I mean, I'm aware of it now because, as I say, I've seen materials in preparation for this. And in fact, I don't think I was aware or knew Nick Jenkins until we did the DCLG work post the Grenfell Tower fire.
Was there given that the BRE had assisted in putting this conference on, if not sponsored it, was there no system at the time in the BRE for disseminating intelligence or information that had come out of the conference, such as a video of it or the transcripts of the speakers or the slides that speakers had presented?
Not that I'm aware of, no.
Right. I'm going to show you an email, and let's see if you can help with it. At NHB 40 is 2864, please. Now, this is a long email chain which straddles January and February 2016, so that before you became a little bit more distant, as you put it. Now, if we go to the foot, please, of page 3, I want to show you an email that Nick Jenkins of Boothmury wrote to Brian Martin in response to his earlier email on the 16th of February 2016, copied to Stephen Howard and Sarah Colwell, and you can see the subject, use of ACM cladding panels on buildings exceeding 18 metres in height. And he says, "Hi Brian, many thanks for your prompt response. In light of the fires that have taken hold of a number of buildings clad in ACM panels in recent years, I also think that the core of ACM panels should most definitely be considered as a filler. Some ACM cores meet the rules of ADB, however, the ones commonly used in the UK at present don't. To the best of my knowledge, there have been no full-scale 8414 tests carried out to date of any wall constructions featuring any type of ACM panel. I am aware that 2 manufacturers of ACM have plans to have such tests carried out. This, however, unfortunately means that no existing buildings in the UK over 18 metres tall that feature ACM panels currently meet the B4 requirements. There are many such buildings, and their numbers are growing. Whilst I appreciate it is for the designer and the building control body to consider if requirement B4 has been met, I do think the current situation is of grave concern. Surely this justifies the requirement for a less ambiguous statement of the rules. With the above in mind, do you think it would be worth setting up a meeting with the relevant bodies and experts represented to review the current presentation of the rules? And my first question is, did you see this email at the time, either copied on to you or forwarded to you by Stephen Howard or Sarah Colwell?
Not that I can recollect, no.
I think it's something you would recollect, isn't it? If, in fact, up to that point you had thought that there were no ACM panels above 18 metres anywhere in the UK built environment.
That's
You'd remember
highly
this?
likely, yes.
Yeah. So just taking this paragraph by paragraph, did you have no knowledge at all, as at mid-February 2016, that some ACM cores meet the rules of ADB, however the ones commonly used in the UK at present don't?
I wouldn't have known that, no.
So you wouldn't have known that. Did you know it?
I don't believe I did, as I sit here now.
No, the difference may sound pedantic, but it's important. You say you wouldn't have known it. What is the reason why you wouldn't have known it?
Well, I think I would remember if I'd have seen this, and it would have, I would have had a memory of that.
That I understand. What I'm really asking is there something in the way you worked and in the environment or in the system that you worked which meant that there were good reasons why this would not have reached your ears or eyes?
I don't think I follow what you're asking.
You say, I wouldn't have known it. Is there something in the way in which you were working, the hierarchy, the environment, the reporting lines, your job, which meant or gave a good reason for why this intelligence didn't come to your attention?
No, I don't believe that's the case. If people had felt that there was something particularly that they needed to bring to my attention, they would have done so. But I'm not entirely. But I say I don't know what discussions they might have had around this.
But I think you agree.
Or if there was a clear recognition, of the issues.
I think you agree, though, that there was no systemic or structural reason why this information wouldn't have come to your attention. I think.
Oh no, absolutely. Yeah.
And looking at the second paragraph,
there was no blocker to that.
No, thank you. No, and looking at the second paragraph, in the third and fourth lines, where Nick Jenkins says that there are no existing buildings in the UK over 18 metres tall that feature ACM panels which currently meet the B4 requirements. Again, was there any reason why you wouldn't have become aware of that, if not known it already?
Well, I was not aware of that.
That's not my question.
But I can't explain, what reasons might have led to that, if that's what you're asking me.
And similarly, there are many such buildings and their numbers are growing. Taking the statement at face value and allowing for its generality, perhaps, is there any reason you can think of why that fact, general though it be, would not have come to your attention either before or at this time? Well,
other than it didn't, again, I can't provide any reasons as to why it didn't.
You're quite certain in your answer that it didn't. Are you sure about that?
As far as I can recollect, I was not aware of this. And as we've already said, if I had been aware of it, and I'm sure I would be able to say now that I was aware of it. So it's...
In the next paragraph, Nick Jenkins goes on to say that his view is that the current situation is of grave concern. That's his opinion. And he goes on to ask the question, rhetorical question, surely this justifies the requirement for a less ambiguous statement of the rules. Is there any reason you can think of why elements of the industry, such as Nick Jenkins, regarded the statement of the rules as at all ambiguous?
I can't speak for Nick Jenkins. I don't know, what he had discussed and what he had presented, but presumably it would be evident from that.
Did you know at the time, or by this time, that there were elements of the UK cladding industry who regarded the relevant provisions of the approved documents as ambiguous and crying out or calling for a less ambiguous statement?
No, I don't recall that.
You don't recall it? And again, is there any reason why you wouldn't have learnt that at the time?
Other than I don't believe I did know that. I don't know any reasons that would have blocked or prevented that. However, if it didn't happen, then the communication was such that it didn't happen.
And Sarah Colwell's reaction to this was one of, I think I've got this right, without taking you to the transcript, it was one of shock. Looking back on it and doing the best you can with your recollection, do you not recall an occasion in mid-February 2016 when she came to you and said, there are, in common use out there, buildings over 18 metres with ACM in them that don't meet the B4 requirements?
No, I don't.
You don't remember her saying to you that elements of industry regarded that as a grave concern and were calling for a less ambiguous statement of the rules? You don't remember that at all?
I don't recall that. I mean, and it's more likely that she would have had any such discussion with Brian Martin, I would suggest, who would be in a position to actually do something about it anyway.
Yes, and in fact, we can see what happens for ourselves in the ensuing correspondence. But that's a separate question. What I'm really asking you to explain is whether you can provide a good reason for what appears to be your complete inability to remember anything about this exchange or this issue or these questions.
I don't think this was brought to my attention.
And is there a rationale, a reason, an objective reason why this topic would not have been brought to your attention?
A reason why it wouldn't have been?
Yes. What was it about your job or the hierarchy or the structure of BRE or what you were doing at the time that would justify this issue not being brought to your attention?
Well, each of the professionals working within the business were experts in their areas, and they dealt with many issues on a daily basis that, they did not, everything that they did was not referred to me. And I mean, that's just the facts around this. And if, as I said earlier, I mean, from the earlier emails, Sarah was clearly in control of what she was doing and was an expert in her own right in this regard, and was no doubt taking the actions that she felt were appropriate in relation to this. And my expectation was, or is, that she will probably have raised this with Brian Martin and would have been having a direct conversation with Brian.
Did you, at this time, February 2016, have regular meetings with Stephen Howard or Sarah Colwell about the work they were doing?
Insofar as they were business group managers, we would have monthly meetings that reviewed the progress and the work that was going on within the areas, but not down to, all the specific details of the technical side of things. It was a more generic 45-minute meeting with other people present where they were reporting back on KPIs, performance, problems that they had in the business with lack of resources or whatever. But it wasn't a detailed technical discussion about everything that's going on.
Who was Sarah Colwell's immediate line manager at this time?
I'm not sure if this was me or Julie Briegeler at that time.
Who was Stephen Howard's line manager?
Well, that would have been similar.
Right. You're not sure, or you can't remember?
I can't remember. I'd have to go back and look at what point, responsibilities were actually handed over
Right.
during the transition.
And how confident are you that in your monthly meetings with both of these staff members, Mr. Howard and Dr. Colwell, neither of them mentioned this industry concern which had arisen and was in the process of being discussed with government, with you? How confident are you that that did not arise at all?
Well, I can't be 100% confident. Of course I can't. But based on what, you said earlier, if it had been put to me in the terms of there were lots of buildings out there and it was a major life safety concern, I think I would have remembered that.
Yes. So we've got two documents we've now seen, the July 2014 minute and this run of documents, both of which involving Sarah Colwell, which made it quite clear, if one reads them, that ACM, and particularly ACM with the standard core, PE, was in common use in the United Kingdom built environment. But your evidence, is this right, to the inquiry, is that you knew absolutely nothing of that whatever?
I was not consciously aware that there was a major problem, no.
Let's turn to a slightly different a different topic anyway, and this is the research carried out in 2014 and 2015 on external fire spread by the BRE. Now, first, can we go to BRE 3043751? This is a report. Which bears the date the 9th of January 2014, prepared for Brian Martin at the department, entitled Investigation of Real Fires, External Fire Spread in Multi-Storey Buildings. Now, if we could turn to page 2, we see that the report was prepared by Nathan Cole, Kira Holland, Martin Shipp and David Crowder, and approved by you on the 14th of January 2014, yes?
Yes.
Now, in fact, the date's wrong, as Dr. Crowder has explained, and it's likely that the date should actually be 2015, not 2014.
Yes.
Do you accept that?
Yes, I do.
Yes. Did you read this report before you approved it?
Yes, I would have done.
Did you undertake a detailed check of the report, or was it a cursory read-through?
I would have read it through. It depends what you mean by detailed. As I say, the part of the approver is not to basically repeat the work, but it's looking for obvious areas that don't make sense within the text that require further clarification. It's at that sort of level.
Yeah. And did you make any comments on any part of the content of the report, or did you suggest any?
I don't recall. I'm sorry, I don't recall.
Right.
I need to see the other.
After it was completed and submitted to Brian Martin, we know that 2 articles were published. I just want to show you each. First, please, CLG 3019445. CLG 3019445. Now, that's the first page, authored by Kira Holland, Dr. Crowder and Martin Shipp. And if we go to page 2, top right-hand corner, we can see the date, April 2016. And if we go to the second article, please, that's at CLG 000194444. I'll show you these in quick succession. That's the second one. It's part 2, experimental research, same authorship, plus Nathan Cole. And that is also, if you go to page 2, please, dated April 2016, as you can see from the top right-hand corner. Taking each of those articles, did you approve them?
As far as I can recollect, yes, I probably would have done.
Yes, that's Dr. Crowder's recollection.
Yes.
Do you know why there was a gap of over a year between the report being submitted to the department in January 2015 and the finalisation of these articles in April 2016?
I don't recall exactly. I mean, there's always a delay between the reports being delivered to the department and getting the approval back, etc., that you can actually go into the public domain with the content. So there would have been some toing and froing, and then obviously I guess there was some editorial work that needed to be done as well, because depending on where you're going to publish the article, there may be some constraints around that as well. But I can't explicitly say it's because of X. It's likely to have been a sort of combination of different factors.
Dr. Crowder told us that he thought one of the reasons for the delay was that these articles spent a long time with you. That's how he put it. Day 230, page 132, lines 9 to 14. Do you agree?
I don't know whether they spent a long time with me or not. I can't recall that. We would know that from the date that they were delivered to me and then the date that I sent comments back.
Do you recall taking a long time undertaking a detailed review of the contents, or not?
No, I don't think these would have been given any special treatment, if that's what you mean. I wouldn't have reviewed these in a different way than I would normally review a report of this nature. I would have used the same principles. Right.
Now, Dr. Crowder agreed in his evidence that the research and the experiments that were conducted for Brian Martin in 2014 and 2015, which formed the subject matter of that report and that these two articles, were in part to provide an answer to the concerns raised by Ronnie King regarding external fire spread. Is that right? That's his evidence. Do you agree?
Well, I wouldn't have known that firsthand. My knowledge of that would have come from what the fire investigation team had told me was the background to this research, because I wasn't involved in any discussions with Mr. King or the department on that matter.
Now, in his third witness statement, Dr. Crowder told the inquiry, and for the reference, this is BRE 3047668, page 47, paragraph 186. I don't think we need to see it, but he said that he accepted that the work carried out for the external fire spread reports was flawed, and then went on to say in his evidence orally to us that with appropriate resources, a better piece of work could have been carried out. And that's what he said, and that the experimental work was conducted under significant constraints, both budgetary and in terms of the time available, so that it wasn't possible, he said, to give the work, and particularly the experimental work, the proper attention that it deserved. That was his evidence. Was that your own understanding of the circumstances in which this work was undertaken?
I'm was not aware that David feels that work was flawed. I would want to understand more about why he has come to that conclusion. Basically, the work that was carried out, obviously the first part is a literature review anyway, so that is the evidence that was available and that was found and was presented. The experimental work was work that was, and the programme of work, as I understand it, was discussed and agreed between the department and the fire investigation team in answer to particular query that they were looking to resolve. The experimental programme was small. It was never, as I understood it, expected to be, the answer to everything. It was looking at one particular aspect, which is presented to me anyway, I understood it was to be looking at the potential impact of having a board in the spandrel panel that was in some way fire resisting, as opposed to having a reaction to fire classification, whether that be I think class O or class 3 they were looking at. And it was basically a comparative study to see whether there appeared to be any direct impact from that. And then depending on the outcome of that work, it may have necessitated or may have required, further study. So it was a small piece of work. I do remember discussing with them at the time of proposal as to whether there was sufficient resources to do even what they were proposing to do, given that we know, it was based around and on the BS 8414 rig, and knowing that, an individual test the real costs associated with that from just a BRE perspective are of the order of £10,000 to £12,000. So, to propose to do 3 different experiments within the budget that they had available to them, there was a discussion around that. But the view was that, and they convinced me that, yes, they could do that work in a scaled-down version and in a meaningful way. And that's why the work went forward.
That was rather a long answer. I think the answer to my question is yes, isn't it? That you understood that there were constraints on the project.
Absolutely.
Yes, thank you. Did Dr. Crowder discuss those concerns with you before the project? Did he say it can't be done for the money or it can't be done in the time?
No,
Very
quite
simple.
the reverse.
Right. I see. So, with that answer, you're disagreeing, are you, with Dr. Crowder's evidence to the inquiry?
I don't know what his evidence to the inquiry was,
Well,
but
I've just
okay.
just
But
put it.
what I've just said to you is my recollection of the events, in that we had, and I don't know if it was directly with David Crowder or whether it was with Keira Holland, as to what we could actually do and whether you could achieve 3 experiments within the budget that was available. And the response was that yes, those 3 experiments could be run within the budget that was available.
Did you agree that do you agree that the research was flawed, as Dr. Crowder tells us?
Well, I don't know, because I don't know in what context he's suggesting that it's flawed. I mean, the experimental work is just that. It's a programme of work. A series of experiments were done, 3 of them, with the different spandrel panels. The results, the data were collected, and the results reported. So to that extent, the report is a statement of what was done, what the measurements were, and what the outcomes of those experiments were. Now, so it depends which context you're talking about, as to whether they are flawed. I mean, there's nothing wrong with the report in the sense that it is reporting what was done and what happened when those experiments were carried out.
Can we go to the published version of this article? The second article, which is at CLG 00019444. And let's look at page 9. And you can see the conclusion just above the blue word references. And it says, overall, the findings from this research show that there is a clear and demonstrable need to ensure that the buildings are designed and constructed so that the fire spread across the external surface and within the external facade is inhibited as required by the building regulations. There is adequate guidance available in the public domain to allow this to be achieved. That last sentence there, which I think you signed off on, how did you understand that conclusion to have been drawn from this work?
Well, that conclusion obviously is relating to the previous sentence also, that you need to comply with the requirements as required by the building regulations, and that if the guidance is followed, then to me that is saying that you will achieve that.
But Class 0 was still retained, wasn't it, at this time, in approved document B as a classification for external fire spread?
Yes, it was.
And yet you had known of its limitations as such for at least 20 years before this report. So how could that last sentence be justified?
So within the context of this report, this was looking at the comparison of the fire resistance requirement, not requirement, there wasn't one, but whether fire resistance actually changed anything in terms of the performance of the spandrel panels compared with the Class O and the Class 3 spandrel panels that were being looked at.
But we've been through this at some length already, but Class 0 was going to be phased out, yes?
That was our expectation.
Yes, but here it was, still alive and well in approved document B in 2016, wasn't it?
Yes, at that particular
Yes.
moment, yes.
Yes. Did you not think to draw that to the attention of government here and at least raise that as a reservation about the guidance?
Well, I personally didn't.
No. The question is, why not?
I don't recall at the time. I don't know why we didn't. I mean, we could have done. But that was, I guess, yeah, I don't know.
Now, I'd like to turn to a different topic, which is testing to BS 8414. In your evidence, we've already examined the effect of privatisation on BRE and the BRE's code of conduct, at least from 2014 onwards. Is it right that the principles set out in that code of conduct apply to all of the BRE's work, so not only to research commissioned by government or other sponsors, but also to testing carried out for manufacturers?
Yes, it would have done, yes.
Yes. For example, testing done for manufacturers under BS 8414.
Yes, it would apply to all of the areas of activity. It was a BRE group document.
Yes, and we saw yesterday, I think it was now, a presentation delivered by you and Julie Briegula to the department, I think in 2004, in which you told them that the BRE, as one of its strengths, was conscious of commercial agendas and tactics of manufacturers, test houses and consultants. You remember that?
Yes.
And I can show it to you
No,
again if you like. Now, on the subject of testing, rather than research work, were there any particular tactics that you knew of employed by manufacturers?
Tactics employed by manufacturers? No, not specifically. I mean, obviously, a manufacturer would submit samples for testing, if you're talking about the bench scale, for example, and they would be tested, and then the report's written, etc. I guess the bit that's always been the weak link from my perspective is the fact that there is no audit trail back to the main production of that product. You just test whatever is provided to you, you write the report accordingly, and there is nothing that links that back to necessarily what is being placed in the market by a manufacturer.
Right. Now, you say that was always the weak link from your perspective. When did you first regard what you've just told us as the weak link?
All throughout pretty much my career, and I mean it's well known. I mean it's always relied on the manufacturer and their integrity in terms of submitting samples for test that are representative of what they are actually selling, and that's well known and it's been discussed, and I've had discussions in the past with the department about that, especially as the European systems were coming on board, where because basically the UK was operating at a level called attestation level 4 at one point, and then it was visibly obvious that the UK...
I think we've got the answer, which is always. Next question, what did you do at the BRE about that problem?
We discussed that with the department, and it was discussed in various other industry fora at length, especially as the European system was beginning to bring some changes, but not going far enough.
Why did you rely on the integrity of manufacturers?
Well, I didn't. The system was set up to rely on it.
Well, indeed. Why? And why was that?
Well, that was vested in history. I mean, I've no idea why it was set up like that in the first place. I don't know.
You don't know?
No.
Okay. But did there not come a time when you became sceptical about the manufacturerer's integrity and wanted to make absolutely sure that you did have an audit trail? Absolutely,
which is why we have always offered, since 2000, since BRE started offering testing services, we've always offered certification services alongside that, which does provide that link and does provide that integrity, but that is voluntary. There is nothing that requires anybody to do that. So, You know, a manufacturer has to volunteer to opt to go down that system.
Now, thinking about full-scale testing to BS 8414 in the period before June 2017, was the BRE alert to the risk that manufacturers might attempt to game any aspect of the testing system?
Well, that was always possible, as I say. You know, it was
Right.
always known that you might get a sample that was submitted that was not representative of what was actually being provided to the market.
Right. So that was interesting. So that was a known risk, at least to you, back from 2000 or
Yeah,
before.
I mean, we had no clear evidence base to prove that one way or the other, but it was clearly, and it was self-evident, that that was a possibility.
Right. And how did you ensure that, given the commercial pressures post-privatisation on the BRE maintained its independence and objectivity in line with the principles set out in the Code of Conduct when it came to a manufacturer who wanted to game a test?
Well, I say the scope of the services that we offered were the same as any other testing laboratory, in the sense that you take the sample, you take the description that they've provided to you, and that is what you can report in the test report and the classification report. If somebody willfully cheats, then the test laboratory has no way of knowing that they have willfully cheated. You would have to rely on potentially that being picked up by trading standards. On rare occasions, competitors might actually inform trading standards that they had concerns about another manufacturer's product. But the testing laboratories themselves are not in a position really to be able to do anything other than faithfully report the results of the test.
Well, is that right? Why couldn't you have a system whereby you had a second pair of eyes on every single piece of the rig that came into the burn hall or into the storage area, was checked off, and then every single piece or component on the rig that was the subject of an 8414 test was looked at and examined by a second pair of eyes to make sure that it corresponded exactly with the drawings? Why couldn't you do that?
Well, so there's two things there. So if we're talking about 8414, I mean, the process, as I understand it, that was adopted in the laboratory for the 8414 was indeed to check off the materials as they were delivered. However, when it comes directly from a manufacturer, it will come with their description on it. So you still have to take that as face value. So if they are doing something different, you've got no way of knowing. You can't tell by just looking at it.
No, I understand that, and that obviously if a manufacturer tells you that what they are testing is X, but it is in fact Y, then I understand what you've said. What I'm really more interested in is the other components of the full-scale test. Mm-hmm. So the rain screen, the fixings, the rails, the backing, which all comprise different components.
Yes.
Is there not a way in which those could have been audited objectively and robustly by BRE staff in the storage room or the burn hall to make sure that what went up onto the rig as part of the full system was exactly as known and corresponded with the list and with the plans?
I understand what you're saying, and it is my understanding that that was normal practice.
Right. Now, is it right that the BRE had a direct financial interest in carrying out BS 8414 tests?
Of course, it was run as a commercial operation, if that's what you mean.
Yeah.
We did
charged.
testing, and we charged a fee for it.
Yes, and that was a revenue stream, a valuable revenue stream for the BRE post-privatisation.
Well, I'd say it's a value. It was a revenue stream. Whether it's valuable or not is a moot point. But anyway,
well,
yeah.
whether it was enough or not is another matter. But it was a revenue stream which you didn't want to lose. Put it that way. It was of importance to the BRE, wasn't it, or was it not?
As part of the overall aspect of what we were doing, it was important. But in its own right, it was not so significantly important.
Now, when FireNet 9 was introduced first, as we saw in the 2000 amendments to ADB, as an alternative route to compliance, alternative to the linear route for buildings over 18 metres. Do you remember, did you or any others at the BRE give any consideration to the fact that that would inevitably be of financial benefit to the BRE?
I don't think that was a primary consideration. Certainly wasn't one of mine. I wasn't particularly involved in that area at the time, but I don't think it was one of the primary considerations. I mean, clearly the parliamentary inquiry and the work that was being done around supporting that, etc., was the work that was going on and the research that was going on. As I say, you know, and as I've already said, BRE was not reluctant in any way to provide Fire Note 9 to BSI so that it could be made into a full British standard. And, you know, the consequence of that, if you like, is then it's in the public domain and it's open to anybody to actually carry out those tests.
Now, it wasn't one of the primary considerations, but was it not a consideration, even if not the dominant one? Was it not a...
I doubt that.
Right.
I doubt that.
Was there any other organisation in the country who was doing BS 8414 tests to BR 135 criteria in 2000?
Well, nobody was, because obviously the standard hadn't been published.
Well, Fire Note 9.
Yeah.
Was anybody else doing Fire Note 9 tests?
Not that I'm aware of, no, not at that time, because it was still almost like a research type test without really any end use, if you like.
Yes. Now, in his evidence to the inquiry last year, Phil Clark, you remember him, told us that he was unaware of whether or not the BRE had been involved in pushing, is his word, perhaps my word, pushing BR 135, but he said he would be very surprised if not, and thought you might have been involved in that. That's, for our reference, transcript day 95, page 40, 1 to 15. Can you assist? Is that right?
No, that's not right. I mean, as you'll see from the previous evidence, I mean, my first involvement with BR 135, if you like, was at the start of the research project CC 1924, and that had already been agreed and contracted, if you like. It was at that point that I first became involved. So there was already a decision that had been taken that BS 8414 was going to be produced and that there would be a classification system to sit alongside that to make it of value, really. So you'd got pass-fail criteria clearly identified. So no, I was not involved in that decision or in moving that forward.
Did anyone at the BRE ever consider whether there could be or might develop a potential conflict of interest within the BRE carrying out these tests while BRE employees were responsible for writing the BRE classification, or indeed the criteria for paying clients?
No, because I don't know is the answer, but
Right.
I wouldn't have thought that was the case, because at that particular time, until BR 135 was actually published, there was no recognition of that, or couldn't be, and until BS 8414 was also published, which obviously came at the end of that project, or towards the end of that project anyway.
At that time, let's take that then as the start point, 2003, second edition of BR 135. Was there any consideration of that question then?
I don't recall there being one. I think it was just...
Do you remember... Sorry.
No, go on, sorry.
Do you remember any discussion internally within the BRE at any time, or with government at any time, about whether it was in the public interest that fire safety testing of building products for the purposes of meeting the building regulations and approved document B should be the stock in trade of a private business?
There may very well have been discussions with government. I mean, BRE didn't offer any commercial testing per se until the acquisition of the LPC testing laboratories in 2000.
Yes,
Yes.
and after that,
Yes.
do you know, from your own knowledge, was there any discussion, either internally or with government, about whether it was in the public interest that private businesses should sell fire safety tests for money?
I don't know. I mean, and I would have imagined that there would have been discussions between the BRE management and the department in the lead up to the acquisition of the LPC testing and certification business. But I wasn't involved in that, so I can't say definitively, but I think it would be quite surprising if there wasn't.
And do you remember whether there was any consideration of making sure that the BRE as an organisation and its staff individually kept at the absolute forefront of their mind the need to make sure that tests were conducted ruthlessly, rigorously, independently, and without regard to the commercial interests of BRE or its clients?
Well, my experience is that was absolutely clear to all staff at all times, and staff were expected to work in the way that you suggested.
Let's then look at some documents. BRE 3011333. This is a series of emails in February 2008 between you and Sarah Colwell. And if we start on page 1 by looking at the second email on that page from Dr. Colwell excuse me, to you, dated the 28th of February 2008. Subject: passive activates this week. Now, what we need to look at there is under certification. And then if you look at that, she says in the third line, the market for the certification business is buoyant, and selling the service should be easier if we can get delivery times down. The recruitment of Colin's replacement is now critical to the performance of this income stream. Once we've cleared some of the backlog, we'll be focusing on the key income sectors which deliver profitable testing and certification income to the group, such as LPS 1181, LPS 1581, and the steel packages. The potential PPG contract has highlighted the need for good response times if we are to win the business from BWF, and also the potential to deliver sizable profitable test programs into the business. You see that?
Yes.
And then the next one under cladding, failure of part of the test rig during a test this week has put the programs back a week, which will impact on NI earned this month. I think that's net income, isn't it?
Yes, I would.
Earned this month, down £10,000. This has delayed Kingspan's installation on the next two faces, and so slowed up the rest of the programme. And then, if you turn the page, please, after the table, you'll see in the paragraph there, it says, if all these potential leads are taken up, we will have delivered 19 of the 20 faces we predicated in the plan. Lead times are therefore a serious concern. Operational efficiencies in the burn hall may help to improve the position, but we may need to look at subcontracting this work to other labs to keep the market moving. But this has potentially serious concerns when the market turns down after the initial interest has been met. Now, let's look at your response to that, please. If we go to the top of page 1, the next day, 29th of February 2008. And in the first paragraph, you are asking Sarah Colwell for clarification about whether all of the work secured falls within one financial year, yes?
Yes, which
Yeah.
financial year is it coming in?
Exactly. And then in the second paragraph, you say, if this is the position, we really need to think creatively about how we can try to increase the efficiency and throughput on the cladding rigs. Is there something we can do to reduce the rig occupancy time? Obviously, we can't discuss this by email, but it is something we need to look at seriously now. On the positive side, this is a great position to be in. Mm-hmm. Did you go on to discuss this with Sarah Colwell offline, as it were?
I guess I probably did, and we would have involved other people as well.
And what was the upshot? The outcome?
I don't recall. I mean, at this time, we maybe had just 2 rigs, and at some point we've now got, the BRE has now got 4 rigs. So that may have been the final conclusion, that there was very little that could be done to satisfy the turnaround times that we were looking to achieve.
And why was this something that could not be discussed by email?
Maybe because it was too complicated.
Well, maybe.
I mean, there's a
lot.
lot of factors in all of this.
Right.
And it would require other people as well to be inputting in terms of the operational throughput and so on.
Right. Did the BRE in fact make any changes to its processes or procedures due to commercial pressure to increase the efficiency and throughput on the cladding rigs, as you put it?
No, they wouldn't have done.
I'd like to turn then to a topic of impartiality and independence. Can we start with your statement, please, at BRE 405624, page 12, paragraph 42. And you say there, as with any other test, the test sponsor is responsible for the design, specification, procurement and installation of their specimen onto the test rig. The BSEN IEC 17025 accreditation standard, and you attach it, which BRE is required to comply with, obliges the test laboratory to remain completely independent and impartial, and also to safeguard the test sponsor's proprietary information. See Clause 4, 2017. You see that?
Yes, I do, yes.
Only information that both the test laboratory and test sponsor have agreed can be made public. If the test laboratory were to become involved directly with the installation of the test specimen, it would be difficult to demonstrate that the requirements in Clause 4 had been met, and there would be the potential for one test sponsor to allege that its proprietary information had been shared with others. Further, if a cladding system failed the test in the sense that the performance criteria set out in BR 135 were not met, it could also be alleged that the test laboratory was in some way responsible for that failure due to incorrect installation. Now, looking at the first part of that, if we go back, please, to page 12, at the bottom of page 12 in paragraph 42, you refer to BSEN 17025 there.
Yes.
Given those obligations, did BRE employees receive training on how to remain independent and impartial at all stages of the testing process?
Training was provided, yes.
So at all stages of the testing process?
Well, the training would have been across all of the business. So it would have explained what people needed to do, depending on who ran the training. I think, as we discussed yesterday, different examples might have been given and different case studies.
Who delivered that training?
The compliance and quality team.
And who was that headed by?
Well, it varied over the course of the years, of course.
Yeah. Let's take the period 2012 to 2016.
So 2012 to 2016, that was probably Scott Palmer would have been the director then. It may have overlapped a little bit with Stephen Phillips.
Scott who? Scott?
Palmer.
Right. And at what intervals was that training delivered?
I don't think there was a sort of regular, it wasn't done on the first Friday of every month or something like that. I mean, it would have been run as part of a programme, or it was run as part of a programme of presentations that the quality and compliance team gave to the staff on the Friday morning meetings.
Now, Phil Clark told us that he never received any such training while at the BRE. Can you explain if he's right about that? Well, first of all, is he right about that?
I don't know if he's right about that or not. I say the training was offered. I suppose one of the weaknesses, I would have to say now on reflection, is that we would not get people to sign in and sign out to that training. So there is the possibility that people never attended and did not receive that training.
Right.
So one improvement that you could make would be to require that.
Right.
Yeah.
So it could be, could it, that Phil Clark either slipped through the net or just didn't go to training or perhaps missed some training? Or...
Yes, that's possible.
Did you ever have any concerns about how to safeguard impartiality in circumstances where BRE was reliant on commercial testing as an income stream?
No, I mean, I felt that, and have always been clear that, and I believed that the staff understood that you need to basically remain completely independent and impartial from the work that you're doing. And we never applied any incentives or financial or any other where staff were forced to do so many tests within a certain period or anything like that. So the guys in the laboratory, the staff that were undertaking the work, just worked their way through the work that they'd got. And, that there were never any, as I say, incentives or anything like that to achieve certain targets or goals. So, and actually I'm not aware of anybody ever raising any particular flags or concerns around this until, of course, what you're going to come on to now, no doubt now.
Well, we'll see what we come on to, Dr. Smith. The inquiry has seen no training logs for anybody at the BRE, which would indicate that they had actually received the training you've described. Is that right? There weren't any training logs?
Well, there were, but individual staff are responsible for their own training logs. And what there wasn't was a centralised training register.
I see. Now, coming back to paragraph 42 of your statement, you say in the sixth line down on that page that there was an obligation to safeguard the test sponsor's proprietary information. You see that?
Yes, I do.
Is it your understanding that that requirement accounts for the fact that it's not standard practice for information about tests on systems which did not meet the BR135 criteria to be made available to industry more widely?
Yes, it is.
Now, you're referring, I think, there specifically to the 2017 edition of BSEN 17025, aren't you?
Yes, that's...
Yes, and you exhibit that. If we go to that, please, it's at BRE 405565. And if we that's the first page of this document,
Yes.
And it's the 2017 edition, as you can see, which I think was amended in March and June 2018. And if we go to page 11, you can see clause 4, which you've referred to, and it's divided into two parts, 4.1 and 4.2, under the general requirements, impartiality, and 4.2, confidentiality, yes?
Yes.
Do you consider that any part of clause 4 would have been incompatible with the decision by the BRE to publish or disseminate information about failed tests? Let me see if I can help you. I mean, I don't want to...
Sorry, I'm reading it, so... Okay, but if you want to take it somewhere...
Yes, but I was going to point out 4.2.1.
Okay.
Does that help?
Yes, I mean, that's part of it, yes.
Yes, and another part, if we can just
Yes.
turn the page, maybe 4.2.4. You see that? Personnel, including any committee members, contractors, personnel of external bodies or individuals acting on the laboratory's behalf, shall keep confidential all information obtained or created during the performance of laboratory activities,
Yes.
except required by law. Yes?
Yes.
Yes. So are those the two parts that you were referring to in your statement?
Yes.
Yes, thank you. Now, if we go up to page 2 of this edition of the Standard, if we go to that and look at the bottom of the text and 5 lines up from the end of the text there, you can see the date. You can see that, in fact, it was published on the authority of the Standards Policy and Strategy Committee on the 31st of December 2017. So that's post-fire. Yes?
Yes.
Yes,
Yes.
yes, clearly. And you can also see at the very top of page 2, 3 lines down, that edition superseded the 2005
Yes.
edition.
Yes.
Can you just explain to us why it was that when you came to do your statement, you referred to an edition of the standard not published until 6 months after the Grenfell Tower fire?
I don't recall why I took that decision at the time. I think from recollection, the changes are not that significant in that regard between the 2005 and the 2017 version.
In fact, it's right, isn't it? The addition relevant to the testing to BS 8414
Yes, it would be. Yeah.
from 2005 to the date of the fire was the 2005 version.
Yes, it would be.
Let's go to that. It's BSI 401726. And you can see the edition date in the top right-hand corner there, 2005.
Yes.
And I take it you're familiar with this edition of the accreditation standard, yes?
Well, familiar as in I know of it, and
Right.
I would have it available to me if I needed it. I mean, I'm not familiar with it in the sense that I can take you to different clauses and whatever now.
Given that in the entire period before the Grenfell Tower fire, the BRE was the only organisation in the country with the facilities to carry out BS 8414 tests, was any consideration given to making it a requirement of testing to BS 8414 that the BRE would be entitled to disseminate or make available the results of tests which had not been successful in the public interest?
No, I don't think it was. I think it was treated after 2003 as any other test and classification standard. So not treated in any special way, but treated in the way that everything else was treated. I'm not aware that it was ever given any special consideration.
Right. Do you know why it wasn't given any special consideration, given the unique position held by the BRE? Privileged, I think, is the word used in the...
Right. Yeah, I don't know why. I mean, I suppose it could be argued that, there could have been other areas as well that would potentially warrant special consideration as well. But I'm not aware of any discussion on that point, no.
Do you agree that it would have been beneficial for public safety in relation to the BRE's work, quotes, in the service of wider society, I'm quoting from the Code of Conduct we've looked at, to insist that failed tests be put into the public domain?
I mean, it's a very difficult subject area around failed tests, whether it's BS 8414 or not. I mean, because you could argue that there's a public interest element and a safety element around any failed test, whether it's fire resistance, reaction to fire, whatever it might be. So, from where I sit right now, if you were going to do that, I think you would have to do it for everything.
Well, you don't have to do it for everything, but
Well,
given the BS 8414 role that the BRE had and the importance of the tests, the outcomes of the tests, do you agree that it would have been beneficial for public safety to have insisted?
Well, it may have been, but I go back to what I've just said. I mean, I think you can argue similarly that some fire resistance failures could be equally important in terms of, not the information that conveys about maintaining compartmentation within a building in a fire scenario.
Yes,
so that's really what I'm trying to say to you.
I'm sure there are
Yes.
other areas as well,
Yeah.
but I'm just trying to focus on this one. Have you ever considered the potential impact in fire safety terms of the fact that BS 8414 results, which had not met the BR 135 criteria, were not published or reported? The impact of keeping those secret?
No, it was not something that we actively considered. We took the view, and my colleague who would have been responsible for the fire testing and classification area at the time would have taken and did take the view, I'm absolutely certain, of following the same principles and the same rules and the same constraints that were followed in all other areas of the testing business.
Now, I want to go back to a topic we touched on before in a little bit more detail, which is impartiality when it comes to the design, installation and checks of a test rig. Can we look, please, at paragraph 45 of your statement again? which is page 13. And you say there, BRE is responsible for the production of the test report in accordance with the requirements of the standard. The construction of a cladding system onto the test rig can take several weeks. During this time, BRE staff will make periodic visits to record construction information. They're not present to witness the construction process all of the time. It is also not possible to know details such as the chemical composition of materials, products, or components of systems that are delivered to BRE for testing, as explained in clause 3.4 referred to above. For such details, including trade names and component descriptions, beyond what can be visually recorded or measured, for example, dimensions or colour, the test report has to rely on the information provided by the test sponsor. It is their responsibility to ensure that this information is correct, especially as they may rely on the test report to make performance claims in the market. If the information is incorrect or misleading, it is my understanding that this would fall within the legal enforcement responsibilities of trading standards. Now, it's quite a long passage I've read to you, and I just want to break that up. Now, first, when you say there that the test report has to rely on the information provided by the test sponsor beyond what can visually be recorded or measured, for example, dimensions, colour, were BRE staff required to make records of those details?
Yes, they were. And I mean, I think you can see from a lot of the information that has been sent to yourselves, there are lots of photographic records with dimensional measurements, rulers, etc., taken in shot to give that very level of detail.
Well, we'll of course look at that with interest, but my question for you is, what details specifically were BRE staff required to record? You mentioned dimensions and colour. What else were they required to record?
Well, they would record the, if it got a trade name, if it was a fixing, for example, the name of the trade name of the fixing, lengths of any battens or aluminium supports with the dimensions and what they were made from. As much detail as they could glean from what they had in front of them, basically.
And at what stages would BRE staff record those details?
On delivery of the samples to site.
And how would the piece of paper, if you like, or perhaps entry on a computer, of what's delivered to site then go to the BRE employees involved in the test?
So generally, that information would be captured and was captured within the electronic files on the shared archive space. And that had, okay, it has restricted access, but the access is restricted to those people in the team that need to know. It wouldn't be free access to everybody at BRE. It would just be to the people working on that particular project.
Right. And you say that BRE staff would make periodic visits to record construction information. What do you mean by periodic there?
So that's my understanding. I mean, they would... So some of them were resident down in the laboratory anyway, so their offices were alongside the laboratory.
Right.
And they would... It's part of their job, if they are running the test, to go and check at various points during the construction of the rig and take records of... you know, what's going on.
Yeah, but I'm asking you, what do you mean by periodic? Let's ask you now about what you mean by various points. How frequently would the burn hall staff check what was going up on the rig?
A number of times a day, but I mean, it's not a fixed, you have to go every 5 minutes. You have to go at the stages during the construction where something new is in effect happening. And
were there particular stages of the installation in which it would be particularly important for BRE employees to go and witness?
Well, I don't think any one bit would be considered more important than the other. I mean, you need to see the construction at its various stages, you know, as it is going on the wall before something becomes covered up. So you would want to see the installation of support frame first, say, and then that might be covered up the next time you go, and you'd want to see that during the process.
And how would a BRE staff member in charge of a test know that a new stage which required his or her presence to observe was coming up? And presumably, would the person building the rig, who might be a contractor, come and alert them and say, I'm just about to put the cladding on, or I'm about to put the cavity barriers in, come and look? Or how would it work?
Yeah, I mean, I don't know from first-hand experience how that worked. I would expect it to be a communication between the contractor and the project manager of that job.
So it's quite ad hoc in a way, just left to the two of them to work out between themselves.
Well, I mean, given that some rigs take 3 or 4 weeks to build and others take 2 or 3 days, you know, you have to have an approach that is flexible to allow that to allow you to nevertheless achieve those gateways and those observations.
Now, you say that the purpose of the periodic visits was to record construction information. I've read that to you, yes?
Yes.
Is that separate from recording details of components which could be visually recorded?
Yes, I think it is. I mean, in my mind anyway.
And how would that be recorded?
What the
construction information? How would the
So largely it was done by handwritten notes supplemented by photographic records.
And the purpose of that was what? The purpose of recording the construction information was what?
That was then required for the preparation of the test report.
If we go to page 22 of your statement, just a little bit on it, paragraph 80, you say this. And the question at the top is, who, if anyone, is responsible for any checks of or comparison between the actual test riggers installed and the detailed drawings provided by the test sponsor? Your answer is, again, as I explained in my answer to question 2A above, the responsibility for the comparison of the installed test specimen cladding system with the detailed drawings provided by the test sponsor remains with the test sponsor itself. It is the test sponsor's responsibility to accept the installed cladding system and sign it off prior to handover to BRE's project leader. Now, is it correct that the responsibility for the comparison between the installed test specimen cladding system and the detailed drawings provided by the test sponsor is the test sponsor's? Is that really right?
Yes.
Not the BRE's?
Well, there's a responsibility there because invariably the test sponsor is employing, in general terms, a third party to carry out the installation on their behalf. So there has to be that connection made. They have to say, yes, this is what I want to test. You have constructed what I am wanting to test.
What?
And that is a contract between those two parties. Okay?
That I understand, but what is the purpose of the test sponsor providing to the BRE detailed drawings of the system if the only organisation carrying out checks on those drawings as against the rig as built is the test sponsor itself?
Well, BRE then, my understanding is, does a high-level check so that you are identifying basically the key component parts. But, you know, it's said in the test report as well, as far as I understand, that because the BRE staff, the guys doing the actual tests, are not architects. They're not trained architects and they're not designers. And so it's difficult to expect them to be able to read a drawing and fully understand whether what's been installed exactly complies with that. So again, you're then relying on the manufacturer's input in terms of accepting responsibility for what is being presented for test.
But isn't the BRE anxious in the extreme to make sure that what goes up on the rig corresponds exactly with the drawings it's been sent, for its own reasons?
Well, insofar as BRE has been able to check it, they do. But I say, I can only go back to what I've just said, and it's my understanding that, we are not taking responsibility for the specimen as presented. That is the sponsor's responsibility.
But why aren't you taking responsibility in your own interests and self-protection to make sure that the system as erected is the same as that drawn in the drawings with which you've been provided?
Well, I say there's a certain level of checks that go on, but it is not within the competence of the guys that are doing the standard fire test to read architects' drawings.
What's the point of the BRE having the drawings then?
Well, the drawings are then presented as the system for test. I mean, I say high-level checks are done if they've said they've used this insulation of this thickness and so on. That sort of check can be done in comparison with the information that's been collected in relation to the products that have been delivered to site.
I mean, in fact, it's not right, any of this, is it? Because in the reports we've seen, certainly the classification reports, the drawings themselves and the list of components is set out in detail.
I'm not aware that there are any drawings in the classification report.
Right. Mr. Chairman, is that a convenient moment?
Yes, I think it is. Thank you very much. Well, we'll have a break now,
Okay.
Dr. Smith. We'll come back, please, at 25 to 4.
Okay,
And as before, please don't talk to anyone about your evidence while you're out of the room.
thank you.
Thank you very much. Thank you. 25 to 4, please. Would you ask Dr. Smith to come back in, please? Right, Dr. Smith?
Yes, thank you.
Yes, good, thank you. Yes, Mr. Bennett.
Mr. Chairman, Dr. Smith, can I ask you please to be shown CEL 401329? This is, as you can see, the BRE test report dated the 11th of August 2014 for Celotex,
Yes.
report number 295255.
Yes.
For some people listening to this inquiry, that number will be resonant. If you turn please to page 6, you'll see there
Okay.
a drawing, system as tested. And figure 1 says construction of the system showing the key layers of the cladding system. And if you go to page 7, you'll see the same,
Yes.
slightly different.
Yes, I do.
Just looking at that is right, isn't it? That in fact, the test reports do.
The classification, yeah.
Yeah, they do set out.
Yes, they do.
They do, yes. So your answer before the break, I think, well,
My recollection was not right, yes.
okay. Now let's go back to your witness statement, please. BRE 405624. And you'll see there paragraph 90 when you went. We need to go to page 25, please, and go to paragraph 90. And there you say this: once a report has been drafted, it is sent to a technically competent BRE approver who has been trained in relation to the BS 8414 test methods and signed off through demonstration of competence to undertake the task. The approver checks that the correct report template has been issued, corrects any typographical errors, and that the system description is consistent with the information provided by the test sponsor. They also check the test data analysis and the observations recorded by the BRE test engineers during their periodic visits to the laboratory during the construction process. And if you go on a little bit further, please, to page 26, paragraph 93, you're explaining the process for writing BR135 classification reports, and you say this: before a BR135 report is issued, it is sent to a BRE approver to be quality checked for errors, including typographical errors. See that?
Yes.
The approver ensures that the correct report template has been used and that the test report number, i.e. the number of the test report which the classification relies upon, test data analysis and field of application sections are all consistent. They will also check that the product description is consistent with the information that has been provided by the test sponsor and the observations recorded by the BRE test engineers during their periodic visits to the laboratory during the installation process. Now, in both cases, both paragraphs I've just read to you, to what extent are the two separate pieces of information, so the information from the test sponsor and the information from the BRE's periodic visits, relied upon by the author of the test report or the classification report?
The author or the approver?
The approver.
That's really down to the approver as to what they want to check and what they do check. I mean...
And what set of information would you consider to be the more comprehensive? Would it be the test sponsor's detailed drawings as against construction information recorded by BRE employees on their way through the burn hall now and again?
Well, I don't have first-hand experience of this, but sitting here today, I would rely more heavily on the eyes and ears and the observations, etc., and the records that have been taken during the construction of the rig by the BRE test engineers.
During the construction?
Yes.
Right. I don't think there are any photographs of the construction process or records of the construction process as opposed to the deconstruction process set out in the reports, is there?
There are in the electronic files.
Yes, but not in the reports that go out to the market, the buyers.
That may be correct.
Yeah,
I'm not sure about that, but certainly the in writing the reports and that, you know, that information is collected and does sit in the electronic archive.
And what should
Yes,
the author
should,
of the report, what should the author of the report do in the event of any conflict between the information from the test sponsor and the information from the BRE's visits, the BRE staff's observations in the burn hall?
The author or the approver?
Well, let's take the author now.
If the author is aware of a particular deviation, then it is incumbent on them, I would say, to go back to the test sponsor
Right.
and query that.
And what about the approver? Same?
Well, the approver, I would go to the author of the test report, I think, initially, and say, look, I've spotted this. What's going on?
Right. But the approver is simply somebody looking at the four corners of the report and checking for typos and obvious errors.
Yes, and anything that they spot. And
So
if they spot something, they would query it and want it to be resolved.
Yes. Now, if we go back to page 21 of your statement, please, paragraph 77, you say this. As explained in my answer to 2A above, BRE's role during the installation of a test specimen onto a test rig is strictly limited by the standards to which it is accredited, namely EN ISO IEC 17025. The design and installation of the test specimen is entirely the responsibility of the test sponsor. Mm-hmm. Now, going back then to page 12 and paragraph 42, you say there, at the foot of page 12, 3 lines up, if the test laboratory were to become involved directly with the installation of a test specimen, it would be difficult to demonstrate that the requirements in clause 4 had been met, and there would be the potential for one test sponsor to allege that its proprietary information had been shared with others. Further, if a cladding system failed the test in the sense that the performance criteria set out in BR 135 were not met, it could also be alleged that the test laboratory was in some way responsible for that failure due to incorrect installation. We've seen that before the break.
Yes.
Now, breaking that down, and those 2 paragraphs I've just put before you down, dealing first with what you say about clause 4, can you explain how would any involvement by the BRE itself in the installation of a system onto its own test rigs make it difficult for the BRE to demonstrate compliance with the confidentiality requirements in clause 4?
So, I mean, the situation is test engineers see many different systems being installed in many different ways. It's not unusual for them to see a manufacturer installing something, or whoever it might be, the test sponsor at least, and during the course of the construction they might think to themselves, well, I know that that is going to fail. There's a weakness in the way that that is being installed, but that's based on their historic knowledge and evidence that they've gained and experience they've gained from watching other tests. So what they can't do, if they're acting impartially and independently, is go along and say, well, if you don't do it like that, do it like this. So that then, removes that weakness from that installation. So if they were actually doing the installation themselves, I struggle to see how you would prevent that sort of unconscious bleed of information across from one test system to another, and in effect the sharing of that proprietary information. And I think that's what the accreditation standard is seeking to do, to ensure that that does not happen and cannot happen.
And forgive me, why isn't it as simple as the BRE staff simply taking the components as listed and as delivered, the plans as delivered, and supervising the build in accordance with those 2 pieces of information? Why would that involve any risk of breach of confidentiality to the BRE?
Okay, so that's different from what you just asked in terms of why did BRE not do the installation?
Well, no, your words are, let's go back. You say BRE's role during the installation of a test specimen on a test rig is strictly limited by the standard. and was entirely responsible entirely the responsibility of the test sponsor. And if the test laboratory were to become involved directly with the installation of the test specimen, there might be a breach of clause 4. That's what you've
Yes.
said in your statement, and I don't understand why that is so. I'm just seeking to get to the bottom of your explanation. And as I'll put the question again: why isn't it, or why does the involvement of the BRE, to the extent of ensuring that what it is told is to be rigged, is actually rigged, something which might involve any risk of breach of confidentiality?
Well, our view has always been, I believe, that you need to take a step back from that. If the test sponsor and or the installer are doing the installation, then they are doing the installation. Apart from taking notes and photographs and observing what they are doing, then BRE can't be involved beyond that, because there is then always that opportunity for them to impart information to that installer or the test sponsor that could help them in some way pass the test.
Well, that last part of the answer I understand. What I'm struggling with, Dr. Smith, and I'd just like your help with this, is why the risk of giving advice, so to speak, or helping to pass the test, is one which is necessarily inherent in following the instructions inherent in the list of components as delivered and the plans as delivered. What's the problem?
Well, I think to some extent that is what they are doing, but they're not they're not signing off the installation. They are watching it, they are recording it, and then they are writing the report and detailing what they actually witnessed. So that section of the report and the details that are in the test report about where the fixings were and what type of fixings, for example, and when the installation was put on, whether there were any sheathing boards and this, that and the other, and what they were, are as they have observed.
Wouldn't it have been possible for installation to take place as a joint task between the BRE and a test sponsor?
No, I don't think that would provide sufficient distance between the test sponsor and the laboratory undertaking the work.
Well, wouldn't it have been possible, in order to avoid the risk you've just identified, for the BRE to make sure that the test sponsor checked the rig during the process and before the test started, and signed off by the test sponsor to verify that the rig was complete in the correct configuration as per the plans, and that the BRE were not to be held responsible in the way in which you suggest in the event of a poor result?
I don't see, I'm struggling to understand why there is a problem with BRE following the construction of the rig and then reporting that factually in the test report.
I'll answer your question. Because of the risk that in following, BRE is following at too great a distance and allowing unscrupulous test sponsors to sneak something past the BRE up onto the rig, which helps pass the test. That's the risk.
Okay, and I accept that in the case that you're talking about, that should not have happened and it should not have been possible for it to happen.
But it did happen.
It did happen.
Well, let me be careful.
Yeah.
There is evidence that might be seen as suggesting that it did.
Mm-hmm.
And if that is so, does it not tell you something about the defects in following, as you put it, as opposed to co-partnering?
Well, I mean, the other thing I would say is, there's been a lot of scrutiny and examination of reports and information within BRE since then, and we have not come across any other example of that failure or that failing in that way, to that extent, in any of the other information we've looked at. and I can't explain, and I mean, it's not for me to try to explain what may or may not have happened in that particular case. But I don't think the processes and procedures that were normal were actually followed in that particular test.
And on that, what processes and procedures that were normal were not followed in that particular test?
There is a lack of...
to be clear, we're talking about the Celotex 2nd
Yes.
of May test on RS5000.
Yes. There are
And just to be clear for the record, you and I, in my questions, are making assumptions about
Absolutely.
what that evidence shows.
Yes.
Just to be clear.
Yes, yes, and
So
with
the
no
answer-
first-hand experience.
So the answer to my question, I'll put it again, is what processes and procedures that were normal were not
Yes.
followed in that particular test?
Yes, so from my observations, there is a lack of photographic record of the different stages during the construction process. And there's actually a lack of detailed photographic record during the deconstruction process.
And can you account for that?
I can't account
Right.
for that.
Now, in what way did any part of Clause 4 of the 2017 edition of ISO 17025, let's assume it had applied during the period 2005 to 2017, how would that have precluded comprehensive checks being carried out on the installation and full records being met by BRE? In the way you've just identified, full photographs.
It didn't preclude
No.
that. I mean, we did, as a normal process, full and detailed photographic records were taken. And notes, of course. We've already mentioned the
So
detailed notes.
we may be able to cut through this. I think you and I agree that there's nothing in either the 2005 or the 2017 standards about impartiality that would have precluded the BRE from taking a full suite of photographs to make sure that what is said to have gone onto the rig did go onto the rig.
And I agree with you,
No.
yes.
And in devising the policies and procedures in the way in which you and I have just been discussing, including the full suite of photographs, was BRE conscious of the temptations or possibilities that commercial manufacturers whose priority was sales to try and sneak something past you?
We were conscious that that was a possibility, which is why, factual records, observations and photographs are taken.
Yes. Did you perceive at any time that it might be all too easy, because of the importance to the BRE, relative importance to the BRE of the revenue stream derived from BS 8414 tests, to lapse into slackness, whereby habits grew up and any divergence between the test drawings and the list of components as delivered and the rig as built might be overlooked?
No, I wasn't aware of that, and that didn't occur to me that would be happening. I mean, we had obviously, UCAS carried out third-party oversight of the various testing activities, including BS 8414, and there were internal audit programs as well, which I would have expected to have signalled any particular issue that might have been occurring within that area or any other area, in fact.
And what about the giving of advice or the making of observations about the conduct or performance of a test as it was happening? Was that allowed?
Well, it would depend what the observations were. If they're a statement of fact, like we've just, terminated the test because we've put water on the crib, then, I mean, clearly that's That's an obvious statement of fact.
What about
But
you might want to try some magnesium oxide boards up there?
That's not permissible.
And so far as you're concerned, was that something that your staff absolutely knew as an article of faith throughout?
Yes.
Can we go to page 17, please, paragraph 60? You explained there, testing and classification provides a consistent means for benchmarking the fire performance of systems against each other and a defined baseline. And if you look at the last 3 lines of that paragraph, you say, as I've explained above, in the case of cladding systems and BS 8414 and BR 135, it is the cladding system that is tested and classified and not the individual components which make up the cladding system. Do you agree that in order for a test to operate as a consistent benchmark against which performance could be measured, the information reported about that test would need to be accurate?
Yes.
Particularly with respect to what it was that had actually been tested.
Yes.
And if you look at page 18, please, the next page, you can see it, paragraph 66. You say in the third and fourth lines there that the whole basis of BS 8414 and BR 135 is to provide a snapshot of the particular cladding system tested. BRE does not have and is not required to have by any regulations or standards any ongoing role in relation to the cladding system. Now, if the snapshot is inaccurate, again, the wrong picture being provided, then the whole system falls down, doesn't it?
Yes, that test becomes invalid.
So does that tell us that the ability of the testing and classification system under the whole edifice of BS 8414 and BR 135 to operate as a reliable benchmark depends entirely on the provision of accurate information by the test sponsor?
Well, and the observations that the test engineers are taking the testers in the laboratory in terms of what's actually going on to the rig. It's both aspects.
Yes, and that would mean that your equipment would have to be regularly and properly calibrated so that it was accurately recording.
Yes.
Now I want to ask you some questions about Kingspan and BRE's testing of K15 insulation, starting in 2004. Now, take it from me that Kingspan carried out their first, what one might call, full BS 8414 test on the 31st of May 2005.
Okay.
Did you have any involvement in that test or that aspect, any aspect of that test?
No, I didn't.
In 2005, I think you were head of the reaction to fire team, weren't you?
Probably.
You say so in your statement of paragraph 8.
That's correct.
Which is where I've got it from.
I did a proper audit to prepare my statement, so yeah.
Yes. Did that role include any involvement in any aspect of testing to BS 8414?
Not directly, no.
What about in terms of supervising others?
Insofar as some of those people reported into me, not all of them.
Right. Now we know that before Kingspan carried out the test on the 31st of May 2005, they had done what they called an indicative test on the insulation alone in December 2004. Did you have any involvement in that aspect of that test?
No, I didn't.
Were you aware of it at the time?
I don't recall being aware of it.
Did you have any involvement in any discussions with either Meredith or any Kingspan employees in 2004 or 2005 about testing K15 to BS 8414?
I don't believe I did. I don't think I actually met Ivor Meredith until quite a lot later.
Right. Were you ever aware of the BRE working with Kingspan or any Kingspan company on potential field of application parameters for or following any particular BS 8414 tests?
Well, obviously, field of application is part of the classification, depending on what you're doing. The direct field of application is part of the classification report. So insofar as people are required to do that, then, of course, BRE staff would have been writing those reports. But I don't know if that's really what you mean. I'm talking there about direct field of application.
In his evidence, Ivor Meredith told us that he and possibly Phil Heath, his manager, had a number of discussions with Sarah Colwell and possibly David Hoare about a test to BS 8414 on the 31st of May 2005 and the way in which that test result could then be used after that. Now, first question is, do you know anything about those discussions?
No, I don't.
Who was David Hoare?
David Hoare was another tester that worked in, various areas across BRE during his time, but no longer there now.
Now, Ivor Meredith told the inquiry, day 75, page 70, lines 5 to 9. There's no need to see it, but he told us that Kingspan had not intended the system that they tested in May 2005 to be representative of a real-life cladding system, which would be used on a building. Instead, that what they wanted was external boards to be used to represent, in general terms, a system with a non-combustible outer layer. That's what he said.
Right.
And the reason he gave for that was that the BRE advised, he says, that if we tested behind a non-combustible building board, they would give us scope to say that the system tested could meet BR 135 requirements when used behind all non-combustible cladding types. And he went on and said, unfortunately, after testing successfully, the BRE moved the goalposts and retracted this statement, leaving us a little in the lurch. Quoted with some gaps there from his statement. He thought that the advice had been given by Sarah Colwell or David Hoare, and then retracted by either Sarah Colwell, Richard Colwell, or David Hoare. That was his evidence. Do you know anything about that?
No, I don't.
Do you agree that any suggestion that testing with one non-combustible cladding panel meant that you could, based on that test, use any non-combustible cladding panel would defeat the entire purpose of classification to BR 135 in the first place?
Yes, I do.
Were you overseeing Sarah Colwell's work at that time?
In terms of line management, possibly. I would have to go back and check.
Right. And did that include her work on BS 8414 testing?
It would have included, if I was her line manager, it would have broadly included everything.
Right.
Although, depending on, as we said yesterday, I think, depending on what the nature of a query was, you would go to others as well to discuss any particular technical aspects of the work.
Right. And she never discussed either position of the goalposts, as it were, any time with you?
Not that I recall, no.
Right. Now, moving on in time, we heard that in 2007 and in 2008 there were 4 tests to BS 8414 Part 2, which were carried out on systems incorporating K15. Do you recall having any involvement in any of those tests?
No, I don't.
Were you aware at the time that those tests were being carried out?
I would have had knowledge that they were, in the sense that at that time the rigs had then been moved from Cardington to our site at Garston and were then in the Burn Hall.
Yeah.
So I would have had an awareness that work was going on in the Burn Hall. I wouldn't necessarily have known the details of that, but I would have known which rigs were being used and what other work was going on as well. I'd have had an overarching appreciation, is what I'm saying.
And did you hear anything from Sarah Colwell or other colleagues about the results of those tests?
No, not directly, no.
Indirectly?
I don't recall at all. I mean, I wasn't involved in the day-to-day testing on the cladding side.
So you don't think or don't remember that anybody told you that they had all failed?
No, I don't.
Now, Ivor Meredith's evidence was that in respect of at least one of these tests, he had received from the BRE official and unofficial comments on the reasons for failure. And he thought that those had come from Phil Clark. Just for our purposes, that's day 75, page 159, lines 20 to 25, and page 160, lines 1 to 7. That was his evidence. Were you aware that Ivor Meredith had asked BRE employees on more than one occasion for their official and unofficial comments and opinions in relation to particular tests?
No, I was not.
Nobody raised that with you at the time?
No.
Can you help? Was it common practice at the BRE for employees to provide unofficial comments to sponsors in relation to BS 8414 testing?
Not in my experience, no.
Was it permitted?
No.
Was it banned? Is it prohibited?
Well, I don't know about... I mean, not permitted is the same, really, as being banned, isn't
Well,
it? I mean,
that is correct. Was it prohibited?
yes.
Right. What safeguards were in place to make sure that those in charge in the Burn Hall of tests under 8414 did not give unofficial comments to test sponsors? What were the safeguards in place?
Well, it's the same as the provision of advice and consultancy.
Right.
It's the same principles that apply to that.
Right. Did you ever come across an occasion when one of your Burn Hall staff perhaps might have demonstrated an ignorance of the difference between giving advice and stating facts observed?
Not that I can recall, no.
Right. Did you ever come across an instance where one of your BRE staff in the Burn Hall thought they weren't giving advice but were giving comments or observations about what they were seeing? In other words, the benefit of their expertise in a more general sense.
Not directly, no. But as we just explored a little bit earlier, the certain observations are permitted when they're a statement of fact. You can see it, it's self-evident, but you can sort of confirm that, yes, I've now terminated the test because I've extinguished the crib. There's nothing wrong with saying that, but then it's that line that you cross. And as far as I was aware, people were clear that they were not to provide sort of any assistance to test sponsors that might in any way assist them in passing a test.
You say, as far as you were aware, people were clear. What led you to think that people were clear that they were not to provide any sort of assistance to test sponsors?
Well, I never had any evidence to show they weren't. So, it was a case of it's difficult to prove something if it's not happened. But,
right.
In general discussions with people, people would say that back to you. People, obviously the training was carried out as well, and people would, in conversation, would say the things, that you were expecting them to say. Nobody said anything that sort of contradicted that and led me to think, hang on a minute, this person doesn't understand what they're talking about.
Can you explain why we've never seen a record of any BRE employee ever telling Ivor Meredith that unofficial comments could not and would not be provided? We've seen no record of that.
There's no record of...
No record of the BRE going back to Kingspan and saying, I'm sorry, we're not in the business of providing unofficial comments. You'll get our test report.
Well, I'm not sure that was ever raised by Kingspan, was it? I'm not sure.
Well,
were any of our staff aware that it was being suggested they were giving unofficial guidance? Because if they weren't, then we're not going to go and write to somebody to say, for the record, we don't give unofficial observations or whatever.
Well, the answer to your question, since you asked me about the evidence, is yes. And my question to you back is, given that Kingspan asked the BRE for their unofficial comments, can you explain why no BRE employee went back to them and said, I'm sorry, we're not in the business of giving unofficial comments. You'll get our report. No. Can we then look at the ways in which Kingspan used their test to BS 8414 Part 1 from May 2005 in the marketing of K15? First, let's go, please, to KIN 405179. This is an internal Kingspan email chain from June 2006, so just over a year after their BS 8414 Part 1 test in May 2005. And if we go to the email at the very top of the chain, it is an email from Ivor Meredith to KILPB Technical Services, K15 Promotional Literature. And it says, please note the K15, what's lurking behind your facade flyer, has been withdrawn by the marketing department partly because it's considered not a good sales tactic to highlight the fact that you don't need class 0 below 18 metres. Also, the BRE have complained about the use of the word approved and certification in our text. These are privileges that would cost us an additional 20k. Now, that's an internal Kingspan email. If we look at the marketing flyer that he's talking about, it is at KIN 405350. And if you look at that, under the first red section of text, that document reads, Kingspan Cool Therm, this is just below halfway down, Kingspan Cool Therm K15 rain screen board has not only been tested by the Building Research Establishment, BRE, and awarded certification to BS 8414 Part 1 2002, but it has also been assessed and approved in accordance with BR 135. Now that language is, to be blunt, inaccurate and misleading, is it not?
Yes, it is.
BS 8414 doesn't certify anything, does it?
No, it does not.
It's a test method.
Absolutely.
And a product can't be tested to BS 8414 or approved to BR 135, can it?
No, it can't.
Only a system can, can't it?
Correct.
Have you seen this document before?
I don't recall.
Do you know who it was at BRE who made the complaint that Ivor Meredith refers to about the content of this marketing flyer?
Not off the top of my head, no.
In his evidence, Tony Meredith told the inquiry, it's day 75, page 124, line 7, that it might have been Tony Baker.
Okay.
Now, he told us that that wasn't the case, and he would have assumed that it was either you or Sarah Colwell who dealt with that. That's day 100, page 54, lines 5 to 9. Is that right? Was it you?
I don't recall that.
Right.
And certainly the person that was running the testing and certification business within the BRE group at that time, it may well have been him.
Him being Tony Baker?
No, Philip Field.
Philip Field?
Yes.
I'm sorry, because that name didn't come up in your answer. You think it might have been Philip Field who
Yes.
contacted Kingspan?
Yes.
And told them off?
It may be.
Right. But you don't know?
No, I don't
Right.
know.
Did this incident, do you remember, give rise to any wider concerns within BRE about Kingspan's approach and tactics in the market?
Well, as I think we've already touched on, there were concerns about the way the insulation industry were aggressively marketing and challenging each other in the market in the marketplace. So we had an awareness that there were issues, particularly in the insulation industry, and an awareness. But beyond that, I can't really comment.
Right. I mean, being more specific, do you remember whether there were any concerns within the BRE about the way Kingspan presented K15's fire safety credentials to its market?
Well, I mean, clearly there would have been around this,
Yes,
and that led to the complaint that you're referring to.
Yes. And did that give rise to wider concerns about its attitude?
I would guess it would have done, yes.
Let's move on then to some correspondence from February 2008 at CLG 1003576. This is an email exchange between Philip Reed of Euroclad and Eurobond he was representing them, in fact, and Brian Martin, who at this stage, I think, is this right, was still with the BRE. It's early 2008.
I'm not sure.
You're not sure? No. If you look at the first email in the chain, we can see that it comes. We go up the chain to the top. You can see that it comes to you from Brian Martin. Yes.
Yes.
And you can see below that Brian Martin's response back to Philip Reed. And let's look then at the substantive email that Philip Reed sends, which comes to you from Brian Martin for info. And he says this in the third paragraph. We have serious concerns about the fire safety surrounding certain types of composite panels and feel that the current standards and regulations need to be reviewed to ensure people's lives are not put at risk unnecessarily. There is a belief that there are loopholes in the existing framework that allows some manufacturers to offer products that are misleading in their sales documentation and are a genuine fire risk for the public. I have attached a very basic briefing paper which covers some of the issues in more detail. Obviously, the issue surrounding LPS 1181 is an issue that you understand well. It would be excellent to receive your views on the matter. Whilst we recognise the standard emanates from the insurance sector, we feel some manufacturers are misusing the standard in terms of fire safety. We are very interested to find out the position on this issue from the relevant divisions within the DCLG. If possible, it would also be useful to meet with the right people to see how this can be pursued. I look forward to hearing from you in the near future. Now, this appears to have, if you look at the first paragraph, to have followed a discussion on the telephone between them earlier that day.
Yes.
And Brian Martin, looking up at the next email, responds some 15 minutes later to Mr. Reed, telling him to take the matter up with trading standards. That's the thrust of it, yes? As you can see.
Yes.
Yes, and then it comes to you from him saying, Debbie, for info. Do you know why Brian Martin forwarded this email to you?
No, I don't.
Had you been discussing any of the issues mentioned in Philip Reed's email with Brian Martin before he forwarded the email to you?
I don't recall that. And the reference to LPS 1181 is somewhat odd.
Why is it odd?
Because that's an insurance standard, and it's nothing to do with the approved document or the building regulations.
Well, we could explore that a little bit more,
Yeah.
but I think time is short and I don't think we need to. But did this email chain come out of the blue to you, or had there been some sort of discussion with Brian Martin before this, which would have meant that you would have understood what all this was about?
I don't recall. Do recall at some point, and I think I put that in my witness statement, because there was a question around marketing claims and so on, and I put in there that I do recall having had a call from Advertising Standards, but I'm not sure when that was, and it was around definitions and so on of limited combustibility and non-combustible and so on. And it may be that was all part and parcel and wrapped up with this as well.
Now, in that third paragraph I read to you, where he refers to loopholes in the existing framework, did you go back to Brian Martin and ask him what he understood all that meant?
I don't remember what the discussion with Brian was directly on this.
Did you agree in 2008 that such loopholes existed?
Yeah, I mean, I don't know what those loopholes were, so it's difficult for me to answer that, really.
Did you not want to ask Brian Martin, given that at this stage he was still, I think, at the BRE, but certainly by this time had been was embedded in the department 3 days a week, so had some kind of insight into what was going on in government. Did you not want to ask him, well, what are these loopholes in the existing framework that allows some manufacturers to offer products that are misleading?
Well, I may have done, but I don't recall what the nature of that discussion was.
Right. Were you aware of any manufacturers creating misleading sales documentation, as Philip Reed says in his email?
Well, insofar as the Advertising Standards Authority were concerned, I mean, they spoke to me in very generic terms on the telephone. They didn't name individual companies, but it was clear that there was something evidently going on. But they were asking in a very generic way about definitions and so on, and where they could find those.
If we go and look at Brian Martin's response to Philip Reed in detail, he says, "Many thanks for your email. As I explained today, if you're concerned that a manufacturer is deliberately misleading people with its literature, then this is something that should be taken up with the relevant Trading Standards Authority. I understand that Eurobond have already made such a complaint to the Advertising Standards Authority, and this has, in part, been upheld." What was your reaction when you read that?
that that's the correct route, that any misleading claims and so on should be brought to the attention of the Trading Standards Authority.
Did you know anything about Eurobond's complaint to the Advertising Standards Authority?
Not specifically, no.
If we then go to BRE 404940 and go to page 3, this is an email of the 14th of February 2008, so you can see 1528. We can see that Philip Reed, who's the author, is writing to, in fact, this is David Sugden, the PFPF, subject fire safety concerns in public buildings. And if we move up the email chain to the very end of page 1, we can see that on the 25th of February 2008, at the very foot of the page, that email goes to Carol Atkinson, I think, who was the BRE CEO at the time, yes?
The BRE Global CEO.
Right.
Yes.
Yes. And that then gets, if you look up the chain, forwarded to you by Angela Richards on her behalf on the 26th of February, yes?
Yes.
And she asks you to prepare a response ASAP to send to Philip Reed, yes?
Yes.
And then the next email up in the chain, we see an email from Angela Richards to you. Mm-hmm. Was she Carol Atkinson's PA? Or?
Well, part of her office, not her PA
right.
as such, but part of her team.
Right.
She had a team,
all right.
support team.
And she says in her email, she says, we have had second thoughts. It would be better to invite Philip Reed in. I will do this, typing up with your diaries. And then your response at the top, on the 26th of February 2008, to Angela Richards, is, Angela, we need to think about this and be very careful. This is Eurobond waging war against Kingspan, which is a constant battle that never goes away for long. Happy to talk through in more detail tomorrow. Debbie.
Yes.
How had you concluded that this complaint related to Kingspan?
I don't know at the time. I mean, all I can say is, we were aware of this battle that was going on in the insulation industry in general, and, it was constant.
But as part of this battle, did you know by now that Kingspan were making claims of the kind that we saw in their flyer about which BRE had complained?
I don't recall seeing that. I mean, I remember seeing some of the advertising material, which all in all got quite shoddy, involving dead rats and so on.
Dead
rats.
Dead rats?
Mm-hmm.
What was that about?
It was one part of the insulation industry, or one company, trying to convey the view that one of their competitors' insulation was toxic, whereas theirs wasn't. It was all
right. Well, we don't need to
poor.
Investigate the mammals.
Yeah.
Why did you need to be very careful, as you say?
It was important that we did not become entrenched in those battles and did not want to be partisan with any one particular side. We had to make sure that we were impartial and independent and maintained our, the right position. We didn't want to be, stepping into one area or the other.
Did Philip Reed get an invitation to come in and discuss these matters?
I'm not sure.
Right.
I'm not sure whether he did or not. And I'm not sure if I would have been directly involved in that, because as you can see, so when I was talking about Philip Field earlier, that's he's copied into these emails as well.
Right. Mr. Chairman, I'm still in this quite long topic, but I'm going to change to a different document. There is no chance that we will finish this evening, I'm afraid.
Well, is that a better point at which to stop?
It might be. It's been a long day, and I'm conscious that the witness has had an awful lot of questions and many documents to look at, and it may be more sensible, before we plough on with this topic, to give her a break.
Well, Dr. Smith, you were probably hoping that you'd finish your evidence today, and perhaps we were hoping that as well, but I'm afraid it hasn't worked out that way. You can't be very sure about these things. So I'm going to have to ask you to come back and continue giving evidence tomorrow.
Yes.
Can
you give us any idea how long we might be tomorrow?
I could say this much. Looking at my notes, and subject to any further questions overnight, we are most unlikely to go beyond lunchtime tomorrow with this witness.
Well, there's some indication.
Okay.
Don't think you can hold us to it, but we'll do our best. All right, well, we'll break there. We'll resume then, please, at 10 o'clock tomorrow morning.
Okay.
And as before, please don't talk to anyone about your evidence over the break.
Okay.
All right?
Yes.
Thank you very much. Well, then you go to the usher then, please. Thank you very much, Mr. Millett. 10 o'clock tomorrow then, please.